Good evening, everybody. Good evening and welcome to the American Enterprise Institute and our third annual Walter Berns Constitution Day lecture. My name is Gary Schmidt. I'm the program director for the project on the program on American citizenship here at AEI. It's a great pleasure to introduce this evening's speaker, James Caesar, who is the Harry F. Byrd Professor of Politics at the University of Virginia. It's a pleasure for a number of reasons, the first being that Jim is someone I've known since, late 70s, and has been a friend ever since. He's also been a particularly good friend since I joined AEI, authoring essays that I bludgeoned him into writing, being a key participant in a seminar series that I directed on Tocqueville and China, of all things, as well as volunteering, I should say, to participate on advisory boards for various civic education projects we've run here. But the second and more important reason why it's a pleasure to have Jim give this year's Berns Constitution Day lecture is that I don't know anyone in academia today who comes as close to Walter in breadth of analysis of the American regime. As you can read from the brief biography we've handed out of Jim's writings run from the philosophic to the meat and potatoes of governing institutions and electoral politics. Like Walter, Jim has his head up, but his feet firmly planted on terra firma. So it's quite fitting that Jim would give this year's address. Now, before we begin, 4 small notes. First, I want to draw your attention to a paper that my program will be publishing tomorrow by David Campbell of Notre Dame. The paper documents for the first time that in states with civic exam requirements for high school graduation, there is substantive and positive impact on civic knowledge, with the greatest gains among African Americans, Hispanic, and immigrant youth, and especially among Hispanic immigrants. And while many of you in this room may not be surprised about that fact, the fact is the national debate over the efficacy of state-run level exams has ignored whether assessments in civics enhance democratic education or not. Once upon a time, a primary function of our public schools. So it's a whole, we hope this, our program, plug. Second, even though she could not be here today, I do want to thank publicly Ann Diaz Griffin, a former student of Walter's, for her generous support for this annual event. This is actually our 4th Constitution Day event, the first being an address by Justice Anton Scalia, and a follow-on panel consisting of my colleague Leon Cass, friend Jeremy Rapkin, and former head of AEI, Krista Muth, that took up the arduous task of discussing Walter's own scholarly corpus. It was at that event that Arthur Brooks, AEI's current president, announced that succeeding Constitution Day lectures would be named in honor of Walter. It was then that Anne, without any prompting, stepped up to provide support for these events. Now, third, after Jim's talk, we'll have time for a few questions from the audience, so please don't hesitate to raise your hand. We only ask that you wait for a mic and identify yourself. And then upon conclusion of that, the question and answer period, we will have a reception for Jim in the foyer afterwards, where I promise you don't have to identify yourself to get a drink. And finally, I do want to head off Jim's almost certain attempt to make fun of the fact that we're hosting this event on September 16th, not tomorrow, September 17th, which is the official federally observed Constitution Day. Before he gets a chance to do so, I just want to point out that we're starting this event at 5 p.m. this evening. And as the Catholics in the audience will know, we can fulfill our obligation to go to Sunday Mass or Mass on a designated holiday of obligation by going to service the evening before, as long as it starts at 5 p.m. or after. So with that pontifical license in hand and a broad interpretation of the First Amendment's free exercise clause in mind, I now turn the microphone over to friend and scholar, Professor James Caesar.
Thank you, Gary, for that very, very kind introduction, and I'm happy you mentioned these other religious traditions that the holidays do begin the evening before. For mine, it's quite the same. I'll just call this the Kol Nidre of Constitution Day. I also want to express my gratitude to Professor Berns who was, of course, my teacher of constitutional law many, many years ago at Cornell University. And from him, I learned what little I do know about constitutional law. In fact, after spending that semester, I can say since that time that I don't believe I've read a constitutional law case from beginning to end, with the exception of Bush v. Gore for technical reasons. And that was because, having studied those cases from the time of the Warren Court, I concluded that the decisions were important, but very frequently in many of the arguments there really wasn't much there. So I rely on friends to tell me which particular opinions to read, but reading a whole case is much more than I can possibly bear at this stage. Well, the Constitution of the United States is first and foremost a legal document. It serves as the supreme law of the land, establishing the basic structure of framework of our federal government, determining the powers of the federal government as well as some of the powers of the states, and delineating a set of basic rights. Yet the Constitution has played another important role, far less remarked upon, that is unrelated either to its status as law or to any connection it has to the United States. The body of thought that went into developing the Constitution and then into explaining and defending it during the debate over ratification comprises a notable contribution to political theory. The American thinkers who were involved in this task engaged fundamental questions of political life. They challenged a number of well-known philosophical positions, and they offered new insights. The best of their work, which found its deepest expression in the Federalist Papers, merits a place alongside such classics in political theory as Locke's Second Treatise, or Rousseau's Second Discourse, or Burke's Reflections on the Revolution in France. One of the topics of reflection in constitutional thought grew directly from the main practical business with which they were involved, making a new government. The two questions that attracted attention were, first, what is the best or recommended way to go about forming a government? And second, how does a government once formed influence or shape thereafter what might be called the public's political epistemology? This admittedly abstract term refers to the way in which people conceive of or process the whole political world about them. Whether, for example, people claim to figure everything out by their own reason, or whether they allow some space for revering and venerating things past and things noble. These two questions are quite distant from current concerns relating to the Constitution, such as the proper scope of the president's power, or the degree of protection that should be afforded to businesses claiming a right of free exercise of religion. I can therefore proclaim, with the usual academic pride, the irrelevance of the remarks to follow. In fact, pushing perversity still further, I can, in the Constitution's own language, solemnly swear or affirm to avoid mention this afternoon of any of the major constitutional principles commonly referred to in public discussion, whether it be separation of powers, or judicial review, or federalism, or checks and balances. Further still, I pledge never to refer to the text of the Constitution itself, neither to an amendment, nor to an article or clause, nor even to a word or term. And this includes capitation, which Chief Justice Roberts plucked from somewhere in the first article to salvage the Affordable Care Act. Needless to say, you will not hear a citation from any Supreme Court decision, current or past. Perhaps then it would be appropriate at this point to pause in order to allow the lawyers and policy experts in the audience to make a quick exit. Now, for those who have chosen to remain, who must be of a more theoretical disposition, I should provide a preliminary point of clarification about the term political theory. Political theory has been defined in a strict sense as the quest for truth or knowledge about political things. It has been distinguished from political thought, which is the exposition of political ideas and which might include advancing a series of arguments to support a certain view or position, which is akin, say, today to tracts promoting a liberal or a conservative line. Now, political thought may borrow arguments from political theory, but its goal is less to advance truth or knowledge and more to advance or further some political objective. It turns out that by the exacting standard of what is political theory, most political writings, including many, many texts counted as political theory, are not political theory. This is certainly so for the, many of the writings defending the Constitution. The main aim of the Federalist Papers, a work written during the ratification debates by Hamilton, Jay, and Madison, was to make the case for the Constitution. Yet it has also been widely recognized that this work, in making a defense of the proposed Constitution, relied greatly on arguments and reasoning coming from political theory, and it introduced important theoretical ideas of its own. In a preface to the volume written by Alexander Hamilton, he concluded his remarks as follows: "The great wish is that it may promote the cause of truth and lead to a right judgment of the true interests of this community." The Federalist Papers, to which I'll be referring today, has two other advantages to commend it. One is that it was connected to actual events and therefore compelled to address certain questions and issues that arose directly from the practice of politics, some of which are not found in theoretical accounts where the theorist can shape and decide what he wants to talk about. The other advantage is that since the Constitution, the Federalist, was tied to an actual event that might occur, namely the adoption of the Constitution, it hazards propositions of what would or would not happen, allowing us, looking back on the work, to judge the merits of some of its arguments in light of what did occur. We have, in short, a kind of controlled experiment for analyzing certain ideas. Now, the first question about the preferred or best way for how government should be made or formed is raised right at the outset of the Federalist, in the opening paragraph of the book. The issue is stated in a very long and complex sentence, a part of which reads, "It seems to have been reserved to the people of this country, by their conduct and example, to decide the important question whether societies of men are really capable or not of establishing good government from reflection and choice, or whether they are forever destined to depend for their political constitutions on accident and force." That's not a sentence that Hemingway would write. Setting aside some of the difficulties of this formulation, the basic issue posed seems clear enough. There are two possibilities. Either government can come into being by reflection and choice, that is, by some humans consciously making a plan to which people would then consent, or governments can come into being by accident and force, that is, by chance and without consent. There's no doubt which of these alternatives the Federalists hoped to see confirmed. If the experiment at hand worked, that is, if the Constitution would be ratified and put into effect, it would support a claim that human beings, using their reason and intelligence, can make good government, and that this is the preferred way, perhaps the only way, to make good government. Notice, too, that the matter being determined here is not merely a local one, concerned with government only in America, but a general idea that would settle a great theoretical question. For many years, I confess, I read this passage in the Federalist without ever entertaining even the possibility of the superiority of the alternative position. The position favoring reflection seemed so obvious and clear as not to require any argument whatsoever. And in fact, at this stage of the book, no argument is really offered. Yet far from being universally accepted, the position supported by defenders of the Constitution was a matter of great disagreement at the time. And a few years later, in the aftermath of the French Revolution, it became a central, maybe even the central point of controversy within political theory. I'll dispense with, for the moment, with the dimension of whether choice is better than force, and focus on the dimension of whether reflection is to be preferred over accident. Now, on the side of reflection, there are the works of so many theorists that deal with the theme of constructing government on the basis of plans derived from philosophy or from some science of politics. This tradition goes all the way back to Plato's Republic, where a city is constructed in speech. Of course, it's to be understood that some of these efforts were not meant as real plans or suggestions, but models for instruction of some kind. Still, the idea of making government on the basis of reason, ideally making it from scratch, has captured the imagination of theorists. By the time we get to René Descartes, the first great modern philosopher, we find him sitting in front of his warm stove in the midst of a cold winter in Germany, recommending the building of a city, just like an engineer, with the engineer using his reason to design everything freely on level ground. But there is, in fact, an opposing view deriving from a whole school of thought with roots in the political theory of Montesquieu and Hume, and which entered more explicitly on the scene in the speeches of Edmund Burke. This view challenges the superiority of the idea of making and remaking government. It does so not simply on prudential grounds, that if a government is made, the project should be executed with great care and perhaps only when absolutely necessary. Such arguments are fully compatible with, and in fact were often made by those favoring the proposition of making government by reflection. No, this school that I'm referring to affirmed the proposition that good government is more apt to result from growth and accretion, which is to say in large part from something akin to accident. Of course, most proponents of this position allowed for a modicum of human agency at the margins, where political actors could inflect things a bit here and there. But it was an error, they said, and a dangerous one, to proclaim the superiority of the idea of wholesale making, or as it was sometimes called at the time, remodeling governments. As Burke observed in speaking of his beloved Constitution of England, which of course has no written constitution, but still the English Constitution, he said, was not, I quote from him now, formed upon a regular plan or with any unity of design. It developed, I continue the quote, in a great length of time and by a great variety of accidents. In parts, he went on, gradually and almost insensibly, the Constitution accommodated themselves to things. The very idea, he said, of the fabrication of a new government is enough to fill us with disgust and horror. By this standard, a day marking the formation of the Constitution, like Constitution Day, should be an occasion for mourning rather than celebration. A national law should be passed, requiring the flags be flown at half-mast as a sign of our repentance, not only for making a new government, but for boasting about doing so. Now, among the arguments in favor of this Burkean position are these. One, the very act of conceiving or remodeling the government has something fearful about it, because it seems to presuppose a total central authority able to make and remake. It endorses or underwrites, conceptually at least, the notion of a central power without limits or restraint, at least at the time that the government is being made. Once acknowledged and accepted, what will prevent this power from being invoked again? Second, human reason is unequal to the task of erecting a plan of this magnitude. It's just too big and complex a job. To cite David Hume, no human genius, however comprehensive, is able, by mere dint of reason and reflection, to effect a project of this magnitude. If, as some say today, you can't make 1/6 of the economy, what makes you think that you could make 9/10 of a political system? Third, the position favoring remodeling government, openly declared, is destabilizing. Remodeling government sets a dangerous precedent. If a government is remodeled once, why not just remodel it again? Just as people are inclined to tear down a house deemed too old or obsolete and replace it with something new and modern, like the Chevy Chase Maryland model of replacing every bungalow with a McMansion. But whatever the merits of this approach in real estate, instability in political life on the most basic issues can have dire consequences. The almost natural process of growth and accommodation that Burke described and praised for the forming of government by accident is sometimes referred to in textbooks of political theory as the organic model. It refers to an almost natural process of development where nature is akin to what happens in biology, like the growth of a great oak tree. With this, in some versions, we find an additional component, the idea that one should therefore be partial to customs and habits that are our heritage. These embody the customs of the past. In another version, there's worship of the principle of spontaneous order, so beloved by those at the Cato Institute. Friedrich Hayek loved to trace this notion of spontaneous order to the Scottish philosopher Adam Ferguson, who gave the following succinct encomium to accident over reflection. Nations, he wrote, stumble upon establishments, which are indeed the result of human action, but not the execution of any human design. This nest of ideas is also sometimes referred to as conservatism. Now, this model stands in opposition to the idea of making, which has no simple name, but which one might call the synthetic or constitutive model. It too makes an appeal to nature, where nature often refers mostly to necessary relationship or laws that the human mind grasps. Now, if the organic view is the definitive criterion of what is conservatism, then it seems that America, at least the American mind, as sketched by the defenders of the Constitution, by definition cannot be conservative. This is a position to which many English and continental conservatives have long subscribed, claiming that conservatism in America is impossible. But accepting this would allow the definition of a word to rule us tyrannically without our consent. Perhaps there's another form of conservatism that is good as the organic variant. One fact, though, is certainly undeniable. An important strand of constitutional thought, by underscoring and elevating the claim that good government is made by reflection, has shaped some portion of the American mind. There are many today who call for a redo of the Constitution. One supporter of this view, Professor Sandy Levinson from the University of Texas, never ceases to quote from Federalist 1. And then he adds, for good measure, another passage from Federalist 14. Is it not the glory of the people of America that while they have paid a decent regard to the opinions of former times and other nations, they have not suffered a blind veneration for antiquity or for custom? It's probably fair also to conclude that the event of passing the Constitution and getting it going, which was touted in the Federalists, has had an impact on subsequent history of the world. Modernity, for better or worse, was partly shaped in favor of attempts to make governments on the strength of the American example. Now, these are highly broad categories, and in reality, political thought and political theory wants to get a little bit beneath the hood of such basic generalizations. And many have raised the possibility that there could be a little less theory and a little more rhetoric in these two models than meets the eye. It's certainly plausible to suppose that many who support the idea that good government is made by reflection would not deny that it might sometimes come about by accident. And likewise, it is plausible to suppose that some who argue that good government results from accident would not deny that it sometimes could come about by reflection. What is being debated here is in the disagreement between the organic and synthetic views is not really an argument about reality in the full sense, but a dispute about doctrines. By a doctrine, I mean a general conclusion, perhaps derived from theory, that is put forward publicly as a general rule, and it is meant to be an instrument active in the world that will influence the subsequent course of events. Political theory itself is rarely rule-bound, which is to say it's rarely doctrinaire. The thinking of proponents of the organic view probably contains such logic as this. Because so much destruction, idiocy, and fanaticism has resulted from comprehensive efforts to remake government, it's best to support a doctrine that good government results from accident. Some of the proponents of the synthetic model might have in mind the calculation that because so much folly, ignorance, superstition, and the like have been built into our legacies, it's probably best to support a doctrine that argues for making government by reflection. While constitutional thought came down initially on the side of making, it occupies a distinct position inside of this category. The authors of the Federalist sought to do the most possible within the framework of the argument in favor of making to take into account all the reasonable concerns raised by these organic objectors. Furthermore, in a way that I'll try to show later, it qualifies the synthetic position and seeks to forge a kind of combination or amalgam between the organic and the synthetic view. In short, we've seen this thus far only half of the Federalist's full argument. I turn now to another facet of the question of how governments are made, which is the theme referred to in the 18th century as the lawgiver with a capital L, and which we today usually call the founder. The process of founding involves setting in motion the idea for a fundamental change, devising a plan for the new order of society, that is, law-giving in the strict sense, and then acting to put the plan into effect. The founder, or it could be founders, perform some or all of these tasks, and the one or those who subsequently are credited with having done the essential work win the sublime status and enter into the elite club of being known as founders. Before saying anything about political thought on founding, it's worth reminding ourselves how often we Americans speak about founding and founders. It's a huge theme of American discourse, academic and popular. And it seems to be far more prominent here than is the case in other nations. Our founders are generally viewed favorably, although, as anyone in the field of higher education will know, there's no shortage of criticisms that depict the founders as defenders of wealth and privilege, misogynists and racists. Either way, there's much talk about founding and founders in America, and we have monuments to the founders and streets named after them. There's a certain looseness in our designation of who we consider to be founders, with the leaders of the Revolution and the makers of the Constitution usually being grouped together. The names of some individuals from the Revolution, like Jefferson and Adams, often receive more attention than those who wrote the Constitution. But the creation of the Constitution is usually considered to be more at the core of the idea of the founding and of the idea of founders. What is it that accounts for the prominence accorded in America to the founders? Now, one answer might be that it is a simple result of the facts of history, objectively considered. It is a reflection, no more, no less, of how things actually took place. We speak so much of the founding and founders because we had a founding and we had founders. They built it. But there's another possibility worth considering. Americans pay so much attention to the founders because of a theoretical doctrine introduced in constitutional thought that elaborated the concept of founding, ascribed to it a positive valence, and attached to it the making of the U.S. Constitution. This doctrine, which begins with the previous insistence that governments are made, served to prime people to look for founding and founders, and to accord founders such an elevated status. Absent this doctrine, we might never have seen the founders in the way that we do. In fact, we might not be calling them founders today. This doctrine in favor of founding is set forth in the Federalist, indirectly throughout the work, but specifically in Federalist number 38, which is the sequel to the first Federalist paper. If government is to be made by reflection, then there must be a maker or makers. Federalist 38, which discusses the theme of the lawgiver, is one of the fuller treatments of this topic in modern political thought, worthy of being studied alongside of surprisingly few other modern works on the subject, among those which would be passages from Machiavelli and Rousseau. Works by these authors discuss such figures as Moses and Romulus. The Federalist likewise surveys some of the great lawgivers of antiquity, including Lycurgus, the founder of Sparta, and Solon. What is interesting about this discussion is that, in addition to emphasizing the centrality of the event of founding to politics, it places America's founding, potentially at any rate, since the founding had not yet been achieved, it places it into the context of these other monumental foundings of the past. More than that, it begins to suggest that our founding will surpass those foundings. Perhaps our founders will come to rival and replace the founders of antiquity. More certainly, our theoretical understanding of the way to go about founding, they say, has improved on the ancient theoretical understanding. Now, I don't wish to contend that there's no such thing as real history, and that we only count as facts what theoretical doctrines encourage us to see. The world is not that malleable. What I am instead suggesting is that that doctrines can influence the interpretation of reality. If the doctrine of constitutional thought may have had the effect of building up founding, it's even more evident that other rival doctrines of modernity have had the effect, they've certainly tried, to tamp down and downplay the idea of founding. This is evident in the organic position. Under this doctrine, because governments are not made but grow, there can't be a maker. The function of the founding and founders thus all but disappears, and history is read or interpreted so that accident or process in history replaces founding. And it's not just the organic doctrine that is hostile to founding. In the political theory from which Americans otherwise borrowed so much, I'm referring to the thought of John Locke, the theme of founding is also downplayed. It is replaced in part by an idea that societies originate in a compact or contract, not by the efforts of some few persons. Liberal theory in general has little place for founding, and it has all but banished the figures of founders from its analysis of politics. Students of the history of political theory might find it interesting to speculate on why American constitutional thought elects to break on this point with so much other modern thinking. Since founders and founding are so conspicuous in classical political thought, they can be seen in the works of Xenophon and Plutarch, among others. The temptation might be to say that American thought, in conjunction with the thought of Machiavelli and Rousseau, is on this point more classical in character. It's also possible to argue, and this would be classical as well, that American constitutional thought, since it arises from and is so enmeshed with actual politics, stays closer to the phenomenon of politics than does organic theory or compact theory. It's less doctrinal, meaning less inclined to deploy ideas simply to change the world. Now, quitting these speculations, it is more important to concentrate on why constitutional thought adopted its view of founding and what effect this view has had. The Federalist account of founders, it seems, was meant to support and endorse the idea of political greatness and to keep that idea alive inside of modern American politics. The Federalist emphasizes, it certainly does not seek to hide or obscure, the fact that political talents and virtues are unequal. The insistence on individuals of such high rank in America is a paradox. The Constitution abolishes rank and formal titles and establishes popular government. Yet those who created this government recognized and underwrote the idea of hierarchy in the realm of political action. They stretched the idea of hierarchy. Greatness is an idea that bids us to look up to something far beyond the normal. The idea of founding keeps alive an aristocratic notion in American politics. As for the qualities that comprise greatness, it's difficult as always to supply a complete list. The Federalist celebrates the courage, both military and intellectual, of the leaders of the Revolution. But it quietly emphasizes another model, which is found in the prudent lawgiver. The lawgiver displays both sagacity and a kind of persistence and boldness, which is illustrated in the account of how the founders pursued the project of the new Constitution with such commitment and almost beyond the limits of the law. The Federalist, therefore, is a kind of modern mirror of princes in which the quality of the lawgiver become the model of virtue. Now, exiting a moment from a discussion of theory, it's interesting to consider how much and how well the authors of this doctrine achieved their goal in the realm of practice. America's lawgivers are the only persons in the world today, excepting perhaps Gandhi and Mandela, who are considered successful founders. The founders of antiquity have been largely forgotten, largely eclipsed by the Americans. Among the moderns, those who have vied for a high status and may have held it for a time have mostly fallen by the wayside. In the former Soviet Union, the outside statues of Lenin have mostly been torn down and their mighty stone ground to dust. The statue of Vladimir Putin, shirt off and abs prominently displayed, have yet to appear. Mao, though still formally credited as founder in China, does not supply the model for China. Even in the case of Ataturk, the modern lawgiver in Turkey, who went so far in transforming the habits and mores of that people, we are now seeing his project challenged and perhaps dismantled. I'd like to turn now from the general idea of founders and founding to the question of the way in which founding took place. It's on this score, as I mentioned, that the Federalist makes one of its boldest theoretical claims by calling attention, and I quote, to the improvements made by Americans on the ancient mode of preparing and establishing regular plans of government. So the Americans, in a way, set forth the fact that they have made an advance over anything in this theory of founding. There are, according to the Federalists, three great differences cited between the Americans and the ancient mode for establishing government. First is the number of founders, where the ancients always lauded one single person, while the Americans admit the possibility and proclaim a few or many. A few would be the principal movers, I suppose, behind the Constitution or behind explaining it, like, say, Madison, Washington, or Hamilton. The many would be every delegate who attended the Constitutional Convention in Philadelphia, all of the mediocrities included. Second is the critical issue of consent. Most, but not all, of the ancient founders relied either on armed force or superstition, which is a kind of psychological force. The American mode relied on consent. Consent may have required some compromises with wisdom. In fact, those today who, in effect, favor force in looking back on the Constitution are those who would like to see the founders eliminate slavery. But consent is key. Finally, the ancient mode, third, did not employ a written constitution, but the Americans did. Now, each of these issues that I mentioned is worthy of a great discussion, but caught as I am between the Scylla of limited time and the Charybdis of my own guilelessness, I'll devote the rest of the talk to the written Constitution. The idea of a plan of government being contained in a written document is a point now so widely accepted and taken for granted that it is almost never noted or commented upon, and it's seldom seen as an innovation. There are, of course, a few who point out that one can have a constitution without having a written document. The United Kingdom, or what soon will be left of it, has no written constitution, though it is the oldest constitutional government in the world, and many consider it to be the most constitutional of constitutional governments. Even here, what has largely been lost in the whole discussion is the case that once was made against the wisdom of a written constitution, which, at least early on, was a pretty important argument. A discussion of the reasons why you wouldn't have a written constitution is for another day, but ought to be resurrected. Yet in looking back to the constitutional period, in this case going back to right after the Revolution and what happened in the States, we see the development of written constitutions, and we see that counted as a major innovation and of great theoretical import. Thomas Jefferson claimed, and I quote, that Americans were the first of the nations of the earth which assembled its wise men peaceably together to form a fundamental constitution, to commit it to writing, and to place it among their archives, where everyone should be free to appeal to its text. And strange as this claim sounds and implausible, I have not heard of it being definitively controverted. Proceeding by means of a written text was necessarily a necessary innovation, given the prior idea of public consent. The public had to consent to something, and it was only by seeing that thing, that is the written text, that people assembled in different places in different times could conduct the exercise. This represents, in fact, the actual history of the event, in which the text of the Constitution was read and debated, sometimes provision by provision, in the state ratifying conventions. Yet the significance of a written text went far beyond the requirements of the procedure of consent. Conceived of as a written supreme law, the written text now became the highest authority placed above government. The authority of government derived from the Constitution, and no office and no official could claim to exercise any power except as that power was consistent with the Constitution. The Federalist speaks of this innovation as follows: the important distinction, so well understood in America, between a constitution established by the people and unalterable by the government, and a law established by the government and alterable by the government, seems to have been little understood and less observed in any other country. Well, that's another way of saying it's quite an innovation. The principle here is that will, even the will of the highest officials, is subordinate to written law. The source of this law lies in the consent of the people, as it was conceived in the process of ratification. This process proved to be an event in the realm of practice that has entered into and altered political theory. One of the great inventions of modern political thought was the idea of the social contract, which is prominent in the works of John Locke. The idea of the contract was widely considered as the juridical source for modern legitimate government. But as its critics like to point out, this idea was only an hypothesis, not an actual fact, something written about in books, but which could not be located literally in history or practice. The use of popular choice in adopting the Constitution took a hypothetical theoretical idea and transformed it into a living or actual legal institutional reality, which has played an important role in the development of modern constitutionalism. Yet, as important as the idea of a written constitution is, still more important is the way in which people have come to regard that document. Just what kind of thing or being is a written constitution, and how is it to be considered? It is on this point that constitutional thought took one of its most significant and innovative steps. From a purely legal standpoint, a written constitution is higher law. All agreed on that. But though higher law, is it merely law or just law? Or is a written constitution a text having a different kind of status, a document that can claim to be regarded with reverence and veneration, a text that can be looked up to and deemed to have meaning beyond its black letter law, and that, in addition, can play some role, a deeper role, one that endows the government with a degree of respect, and that helps to give birth to a community and to supply a bond of attachment for the citizens that holds the nation together. It is this proposition that is put forward in Federalist number 49. It is here that the idea is promoted of attaching reverence to the Constitution, and through it to the whole structure and plan of government and of the founding. This proposition is not itself found in written law. It is nowhere set down in the Constitution that it should be revered. It was a product of constitutional thought, an unwritten law to be created by a theoretical doctrine. Here is another instance where many today find it difficult to see and grasp this point, since many have already come to consider the Constitution in a certain way as something to be looked up to, a little bit anyhow. Yet there's nothing intrinsic in a written document called the Constitution that would make it be regarded in any way with veneration. There's nothing logical that connects reverence or veneration to what, after all, are only words on a page. Evidence of this contention may be found by consulting people's posture towards other constitutions today. Even today, it's a strange kind of person who would profess reverence for, say, the Constitution of Illinois or New Jersey. These constitutions do not have this status. Furthermore, there's this historical fact. I've spoken with many historians who have told me that there was no idea, and certainly no expectation in 1787, that anything like a sentiment of reverence would be attached to the Constitution. Constitutions were simply not yet endowed with anything resembling this quality. The doctrine of attaching reverence to a written constitution was hotly contested. Thomas Jefferson, who did believe that constitutions were higher law, nevertheless strongly protested the notion that constitutions should be considered from the perspective of veneration. His proposal that all constitutions should expire after 19 years, incidentally an idea that is found in some state constitutions, that may seem odd or quixotic to us, but it was not regarded as such at the time. Constitutions, he believed, should change and keep up with the times, just like any other law. A constitution was higher law, but still ordinary law or merely law. What were the reasons for moving to attach a degree of reverence to a written document? One of them is surely practical, though practical in the largest and most expansive sense. It derived from the observation that pulling off the feat of writing and passing a constitution was highly difficult. Those who took part in this event were sensitive, even awed by how challenging this task was, and they believed it was unlikely that it could ever easily be pulled off again. Certainly the risk of trying to do so could destroy the community and create instability in the process. Better than to lock in again, and by endowing the Constitution with reverence, ensure durability of the Constitution. This durability would connect the American people also to the founding. Yet there was another reason for asking for the Constitution to be venerated. It was the importance of introducing the idea of veneration itself as a mode of thought in the public mind. Instead of veneration being introduced, therefore, to maintain the Constitution, understood in a certain way, becomes a vehicle for introducing and encouraging veneration. At bottom, therefore, the issue was one of shaping the public's political epistemology. On the one hand, there was the idea that public political epistemology should be simply a rationalist one. As Jefferson wrote, no experiment could be more interesting than that we are now trying, and which we trust will, in the end, establish the fact that man may be governed by reason and truth. This is the idea that was introduced by the Federalists at the outset in the claim to make government. This view is never repudiated, but it is surely modified and qualified. The Federalist wants a people that is in part shaped by the idea that reason should govern, but also a people held in check by a capacity to revere and to venerate. No doubt these two cannot be fully reconciled. They haul and pull at each other, but perhaps the best place to be is somewhere suspended between them. For this reason, I chose, upon solemn reflection, to place Federalist 49 on my license plate. By this means, I hope to remind all on the road of the importance of fidelity to the Constitution. I wish to remind especially the willful who tailgate of the need for restraint. And I wish to remind all of the importance of veneration. This is the proper spirit, I believe, in which to observe Constitution Day. Thank you.
David Brazel. I'm here as a private citizen. You mentioned veneration of the Constitution. Historically, as a desire by the founders, but historically, when did that develop, in a sense? Today, we have this veneration for the Constitution. Was that the same thing in 1845, before the Civil War, say, or early on? Can you give us some historical...
Yeah. I believe the doctrine proposed in Federalist 49 began to take hold. I can't say exactly when, but it is interesting to look at the point where it becomes really hotly debated, which is in the late 19th century and into the progressive period. It's at this point that scholars looking back, and I'll say something about these interpretations in a minute, began to speak of the emergence of a cult of the Constitution. I think Edward Corwin, among others, spoke of this. That the Constitution was so revered that it closed off all rational analysis and, of course, made change of the Constitution impossible. It was likened, therefore, that the word cult is important, to a cultic belief, a belief which shut the door on rational thinking. And, of course, this is what I mean by public epistemology. What really is at stake here, if you venerate too much and revere too much, you no longer can think rationally. That was the argument of Jefferson, why you didn't want to go down this path. It would destroy or undermine how people think and change the mode in which they think and process reality. So this became a strong complaint throughout progressive literature, decrying this thing called the cult of the Constitution. A long book and a very good book was written on the history of the Constitution by Isaac Kramnik. What's it called? The Machine That, something like that. Machine That Works by Itself. I forget the exact title, but it's a very good book. And in this book, he began with this notion of the cult of the Constitution because this was the prevailing view. And he set about looking for it and meticulously goes through all this period of time, and he can't quite find it. He doesn't find anything like a cult. Of course, he never disputes the idea of a cult, but he's a little troubled at the end of 6 chapters, showing that there was no cult. It turns out, I think, pretty clearly that the notion of the cult of a constitution, a veneration to that extent, to the point of irrationality, was really a creation of those who opposed the Constitution and wanted to make the idea of support of it so abominable as to undermine support for the Constitution. It was a great rhetorical ploy. If there is anything that begins to resemble more cultic elements of the Constitution, it probably was in reaction to this accusation of the cult of the Constitution by the progressives. So we have the building here in Washington built during Hoover, I think, called it the Temple to the Constitution. That's the National Archive building. And, you know, if you look at the iconography of that building, you come up the steps, and you used to. You come up the steps, and you enter, and it's like the Holy of Holies. And there on a pedestal in the ark is nothing but the Constitution itself. And perhaps then in the 1920s and 30s, in reaction to the progressives, you did get some cultic-like elements, though I doubt not really that strong. Andrew Ferguson wrote a brilliant article, as he usually does in the Weekly Standard a month or so ago, about the new entrance to the archives. I say this now because I was a member of the Archives Commission under President Obama for 1 year and President Bush for 4 years. Have a great interest in the archives, but they redid it, the archives, and I think you have to enter through this display, as he describes it, where you read every element of how bad the founders were or something. And then I think you come in, as he has described it, and instead of looking up at the Constitution, you look down at it. I haven't yet visited the display, so I can't confirm that. But that's dismaying. That would surely be the end of a cult when you look down on something. So that's a little bit the history, so far as I know it, of how this developed. And I can't say exactly when it started, but certainly you get an element of this in Lincoln's Lyceum address that was already evident in the 1830s. And the strong movement of the American Whig Party to qualify a rational perspective and inculcate into the American mind the habits of reverence and veneration. That's a large part of the, you could say, the writings of some of those in that party, to make that a far greater theme, and therefore an open critique that took place at the time on Enlightenment thought and an open critique of what was even then called Lockeanism, which was a critique was so prominent in the 1830s and 40s.
Well, my question is in regards.
Where are you?
Sorry.
Oh, there you are.
Yeah, sorry. I'll stand up. It's better. My question's in regards specifically to the written Constitution. Now, I was sort of like, overhearing what you're saying and sort of listening a bit carefully. And I know that there was a debate, I believe, between, I want to say Madison, and was it Madison and Jefferson, between whether or not the Constitution should actually be written. And I'm curious, like, what was sort of the nature of that debate in particular?
Okay, there was a debate between Madison and Hamilton, a very famous one, which began in Federalist 49, and which they carried on in conversation and in writing, about whether the Constitution should be rewritten automatically after, let's say, one generation. Jefferson favoring the idea that the Constitution should be rewritten, because as I said, it's higher law while it's in effect, but it's ordinary law. It plays no other function than law. And so he said, since the human mind will progress, we'll just redo it in light of circumstances. There's no reason to revere a constitution. And Madison, it's in reaction to that in Federalist 49 that Madison makes the arguments in favor of an enduring constitution which is in a way promoted by reverence towards the Constitution. So they never disagreed on the fact of writing the Constitution, but on what form it would take, whether it would be perpetual or short-lived. On that theme of writing a Constitution, that's a little strange, but there were people, maybe not in America, who thought that writing a Constitution was a pretty poor idea. A French conservative, très conservative, Joseph de Maistre, went after the idea of a written constitution, calling it an absurdity and a very poor idea. And there's some good reasons why there might not be, why one might not want a written constitution that I can think of. I mean, one idea is that a constitution sketches the government, but a government in certain circumstances might never be able to act for reasons of states in accord with the Constitution. We run into this problem all the time in written constitutions. What happens when all the good rules of the Constitution can't be maintained and yet society continue to survive? So you have to break the Constitution. So that undermines the idea that the Constitution really can shape a government, or so some might argue. And this is Schmidt's argument as well about emergency. In emergency, the law has to take second place to not just the facts of the situation. Another idea I would think of against a written constitution is this. There long had existed notions of higher law. It's just that it wasn't written. The higher law was a natural law or God's law. It wasn't written down, but in constitutional regimes, the king or whoever it was bound in theory by the higher or natural law, which was never written down. That was the problem with it. It was vague and could be interpreted. Still, it was a check on power. You could say the idea of a written constitution maybe replaces the higher or natural law with merely written law. So is there a place for natural law inside of the American Constitution? Or, by writing the Constitution, have we made written law the supreme master? This came up in the Thomas hearings initially. Can you say that there's some idea of natural law that's active? And then, of course, maybe the worst thing about this, once you have written law, the ones who are most qualified or think they're most qualified to interpret it are, of course, the lawyers. They're the interpreters of law, whereas under natural law, the ones who are most qualified, supposedly, to interpret it would be philosophers or theologians. So they're, in a way, written out of business, and they get corner offices in the universities with unclean halls, and the lawyers get a higher status because they're the ones with the stamp of approval. So anyhow, to make a long story short, there are lots of different reasons why maybe writing a constitution isn't a good idea. Some of them are implicitly I think, supplied inside the Federalist Papers itself. Maybe the same reason why you don't want a Bill of Rights could be applied to the Constitution, maybe, or something like that.
Okay. Yeah, hi, Kenneth Rothschild. Isn't there a way that we can venerate a constitution, not necessarily ours, and a constitutional process, and also have that respect for a constitution where we can go on and analyze whether or not ours is working as well as it could be? Because if we don't go back to the process of what are the objectives of the Constitution, it's a decision-making process. So my question to you is, in our culture, there doesn't seem to be this reflection of whether or not our Constitution is truly serving the needs of today, and we get carried away too much with the veneration of the piece of paper and not enough with the process and the fact of developing a good, workable Constitution.
Yeah, well, there's judgment there, but I certainly agree with you. I mean, too much veneration, simple or blind veneration, a cult, prevents you from being able to question or think. So if that were the sole component of what I call the public's epistemology, that would be a severe problem. So I was thinking in the Federalist, you have a balance. There's a strong emphasis on reason, and this is appealed to by those who want to change the Constitution, and a strong emphasis or some emphasis on veneration. And I think that if you consider this is probably the best that you can do. So, either one by itself possesses dangers. Well, there was just a meeting of the Federalist Society, for example, that proposed the idea of rewriting the Constitution. I think, there's veneration, and then there's something we call reason that supports veneration. So veneration is something that maybe doesn't demand reason, but veneration could be reasonable. That is, you can reason, some can reason to why they want to support veneration. And the answer might be Harry Reid and Nancy Pelosi. They would be delegates to a convention and leaders. And the question is, could they do as good a job as the people in 1787? So it's fear of what could be open that may make some people rationally push the object of veneration, fearing the quality of the minds that would redo the Constitution and their ability to be able to really make improvements. I mean, the great question in political theory is has always been called the question, can you get consent for wisdom? And the answer is it's pretty darn tough to get. It can only happen rarely. And that's one of the arguments of Federalist 49. They say we had all of the circumstances operating in our favor that you could imagine in 1787. And it's rare that those circumstances will ever occur. We all hated the British. We all just came out of the Revolutionary War and felt a little bit good together. And on top of that, we had George Washington. Those are conditions which would allow something like this to go through under the guidance of intelligent people. Put yourself in the future. You don't have a common enemy you hate as much. Your people aren't as good, and their minds aren't as good. That's for sure. And so this would give you pause. So one of the ways of reconciling these two has been spoken of as rational veneration, which people speak of. But rational veneration can only take you so far. Rational veneration is the veneration which the few understand. But veneration is really what the many are engaged in.
Thank you, Gerald Chandler. Isn't it in practice that there's really very little difference between a constitution that's created and a government that grows organically? After all, what we have today governing us, our Constitution, with a Supreme Court that acts a way that was never expected, an expanded presidential power, and a Commerce Clause that wasn't intended to act the way it does, shows that we don't have what we had. And on the other hand, in Britain, They have an unwritten constitution that's nearly written, and in fact is almost the same as our constitution.
Yeah, on the last point, I would dispute whether the British Constitution is almost the same as the American Constitution. They're both liberal democracies and everything like that, but they certainly have different ways of operating that are significant. Though I would agree with you, but there have been some ways in which you've seen a convergence. I mean, the Prime Minister used to be within the cabinet, and now at least he tries, as long as he's in office, he tries to be like a president and relates to the public more as a president, as a single leader, diminishing in a little bit the cabinet. So I dispute that, but of course you're right that there's some interplay between writing and organic development. I wouldn't doubt that. And our current Constitution today in practice is some combination of the two. And we admit that, even members of the Supreme Court seem to admit that when they say this really is unconstitutional, but to undo it would be to undo a lot of precedents, which they sometimes admit to. So I don't dispute the main point, but I still think that the written Constitution structures still the main features of U.S. government and provides the basis for at least its main components, and why now, despite all the dispute about the powers of the president, there's at least some pushback from Congress. The reason they push back, or some of them, in part is on the basis of the Constitution. So we'll see what happens. It gives them a basis for making a claim. It's not self-enforcing, but a basis for making a claim. And certainly the Supreme Court has powers deriving from the Constitution that it's able to exercise despite what others think. So I think the written element is still pretty important.
Hello, Fratkin. Jim, you, in speaking about the question of veneration and the question of the founders, so the veneration, there was veneration of the founders, not of the document itself, it seems. And that veneration was presumably attached to their claim, which you cited earlier, that they had a special, unique insight into the necessities of popular or Republican government that was better than anyone else's in the past, based on a lot of solid evidence that Republican governments failed in the past. So it struck me that if it is the case that their account in the Federalist of what the liabilities and vices are, and what they have done to address them is genuinely superior, then they're entitled to the veneration, and we're entitled to venerate them and the document that they produce. The question, therefore, is looking at what they claimed and what developed over time, is there something you think that they seriously missed about what would be the liabilities, the problems of this government? And if not, then they're entitled to their claim, and we're entitled to venerate them.
Well, I never suggested that they weren't entitled to this. I just said that they point out indirectly, because after all, they're modest men publicly, and they don't begin like some others, they don't begin every sentence with I. But surely, if you read between the lines, you see that they have set up a doctrine of founding, independent of what they did, which is massive, and claims to elevate this principle. That was part of the point I was making, is that they really claimed that this was a founding of the first order of magnitude, as important as anything we've seen historically, et cetera. So they built up the idea of founding. They also, of course, let it be known indirectly that they're entitled to the idea and the veneration which they stipulate should go to a founder. As for any mistakes that they had in the whole Constitution, there probably were few. I wouldn't want to begin by saying exactly which one. They never quite worked out the issue of the relationship of the federal government to the states. the question is whether the enumeration of powers is a plausible way of dividing the powers up in perpetuity that would work. And it hasn't quite worked, in part by its vagueness itself right from the beginning, in part by amendments which have come in and changed things. But I'm not sure that that worked, and I'm not sure that Madison believed that enumeration ever could work as a method really of restraining. I think he was looking for other mechanisms. But that clearly today, in my view, would be a huge, one of the largest constitutional problems. The notion really of a significant role for the states in many areas, in areas which I think commonly would have been understood to be within the province of the states, is just easily swept aside. In fact, sometimes it's swept aside without even people thinking that they need to argue it. It's astounding to me how many, for example, take the step of the government slowly moving down the path of setting a national curriculum, which is going to be the outcome of where we're going, without even worrying about the issue of constitutionality. It's all debated on the issue of policy, the policy reasons for and against, but the major constitutional issue is simply forgotten or set aside. And that applies to people on both sides of the political aisle. Not only might the founders have been dismayed by this, but certainly Alexis de Tocqueville would have been, that this question isn't raised. Because as you take power away from any entity, then you take away the incentive to participate and be concerned about it.
Well, please join me, if not in venerating Jim's presentation, at least giving him a good hand for it.